Welcome everybody to the next episode of the Cannabis Review. I'm delighted to join in this episode by John Purow, who's a partner at Greenspoon, Marder, LLC based in New York. How are you keeping today, John?
I'm good. Greenspoon, Marder, LLP. All right. We lawyers are precise about our words and letters. You know, me do words good. That's how me don't want to do math. That's why I ended up being a lawyer. Thanks for reaching out. We're linking up right now because of this momentous thing that, potentially temporarily momentous thing that happened in the New York industry right now. And so the very, very quick snapshot, right, is that New York legalized adult use marijuana over 2 years ago. Okay. And then New York wanted to ramp up, and they decriminalized. There's always a gap between when it is no longer criminal and when an actual adult use market launches. And the people that benefit the most during that period are unlicensed illicit operators. And New York is very similar to California. And what happened was that, estimates in New York City alone, 1,400 unlicensed stores popped open, selling legitimate product from mature markets like California, where it's very difficult, frankly, and the only people making money to some extent are people selling stuff out the back door, high-end counterfeit products. And I just heard from a friend last night that some of these stores are selling psilocybin chocolate bars in child-appealing packaging, right? And so that's one big element that happened in New York. And then, in order to, get sales started soon, and also to help, upstate, a lot of hemp farmers there who've been hurt by the CBD market, they created this, conditional, there's all these conditional programs that have opened up to kind of accelerate the process of starting sales. And so I kind of call them like the hemp crossover licenses. So they're conditional cultivators and, processors. And they were able to start making, there was a bill passed afterwards creating conditional processors and cultivators, just in time, I think, for, a planting season. And so all of a sudden, there are the seeds are going in for ultimately will be, what were and, was an estimated $700 million harvest with nowhere to sell. And so the conditional retail program was created. And all of these programs, please keep in mind, are unique to New York. There's nothing been done like this before in the industry. And any law has unintended consequences in an incredibly complex industry like cannabis, where all these pieces tie together. Those unintended consequences, increase exponentially. And so this, conditional adult use retail dispensary program was created by the regulators, by the Office of Cannabis Management, right? And you have to meet these very specific criteria to qualify, being someone with a specific type of marijuana conviction, showing that you were harmed, by the war on drugs, but to ensure that you know what you're doing when you're operating a business, to also have had some history of ownership in a profitable business. And so they get this program up and running, conditional retail. I say we're going to hand out 150 licenses, 1 month to apply, 900 people apply. And then after it closes, the regulators, and I have a podcast we're about to relaunch where we cover everything in the industry. And I've never seen anybody do what New York regulators did here in terms of after people had applied, right? Everything's said and done. They keep on making changes, right? Well, for one thing, they double to 300 licenses they're going to hand out. Oh, there's also this whole other idea of we're going to have this fund, $200 million, 50 from the state, 50 from a raise of investment, where we're going to, allocate $1.5 million or $2 million to each of these CAURD, conditional adult use retail dispensary licensees that we hand out to for the property and the build out. We're going to help you find the sites. And lo and behold, in something that ambitious and a place as densely packed as New York, that wasn't working and no money was being raised. And so after the application window closed, they decided that they're going to change the program. You could use your own property. Then they realized that more people have their own property in certain means than they thought, even though it might not have been the right, idea. And, it's $700 million. I call it Farmageddon, right? People literally bet the farm, to put seeds in the ground and transition over from the struggling hemp and CBD market to take a chance on the first grow in the New York cannabis market. and there's going to be no place to sell. And so they after the fact, OCM again, right? 150 licenses we're handing out. You could use your own properties. We're going to double it to 300. We got to sell all that weed. And then recently, they even increased it. I think there's a total of 463 CAURD licenses now. And they also, after the fact, they change and say, oh, we want you to be able to sell like immediately, delivery out of the retail stores, whereas that had been intended as a separate license. And then also, I think it's separate license on delivery. But sorry, New Jersey and New York bounce around in my head sometimes, and I'm on short rest from the fantastic networking event. And then, but on-site consumption definitely intended to be a separate. Delivery was not a separate license. Sorry, but on-site consumption was always intended to be a separate license, and lo and behold, they will allow these CAURDs to do on-site consumption. What they shifted, by the way, in terms of like the intended regs for full use for CAURD, what I was referencing in terms of delivery was a concept of you could start sales ASAP out of a temporary delivery location because they're just trying to get, to address Farmageddon and get weed out the door. Now, the way that I've actually described all of this is in a way that's kind of sympathetic to the regulators. And what I'll say is I always do the disclaimer. I thank them for their service. I think they have great intentions of coming in and helping people who've been harmed by the war of drugs, especially in states like New Jersey and New York. And they certainly can't please everyone. And they're dealt, certain cards by the law that they're handed. And in this instance, the conditional processor and cultivator laws. So I've kind of portrayed all of this a certain way. And then what inevitably happens in every single state are lawsuits, right? And those throw a wrench in everything. And they're lawsuits you can predict because, in every single state, right, the drug is federally illegal, right? Can you blame local politicians and regulators for trying to, when the entire industry is going to be inside their state, favoring people from the state versus what I call the can of carpetbaggers? All pop puns are always intended, right? So they come up with things to favor people in their state. And then there's this, dormant commerce clause issue, which is like so incredibly frustrating that the drug is federally illegal. But according to this concept of the dormant commerce clause, if regulators come up with something that favors their own residents to the detriment of people outside, since commerce is supposed to be just, like interstate commerce is just supposed to be governed by, Congress, they will knock out those regs. And there is a, dormant commerce clause has an almost 100%, track record in multiple courts around the country. So a lawsuit comes in like that, holds up the awarding of licenses in multiple regions. But then what's different and is specific to New York and these moves that the regulators did in creating the entire conditional adult use retail dispensary that was not in the initial MRTA, the law that legalized adult use. Two lawsuits come in, right? The first one is a lawsuit, nicely packaged and intelligent packaged by some of the biggest companies in the industry, called multi-state operators who own the medical licenses, the handful of medical licenses in New York State, right? And these are vertical. And they're the only ones who could be vertical, and they're treated separately and in many different ways. But there's a lot of stuff in the initial proposed laws that were not friendly towards any type of big business, and specifically these folks. And one thing was saying, you're not going to be allowed to sell and cross over to adult use for years. And so with the CAURD program, every single lawyer, we all saw a vulnerability from the beginning, right? It said in the law itself, the legalization law, that the application period for all retail dispensaries had to be opened at the same time, right? The CAURD program created by, OCM, the regulators, to address Farmageddon and everything, didn't do that at first glance. Theoretically, anyone could apply, but they wouldn't have a shot because unless they have the very, very specific scoring criteria. And so, what ended up By the way, like I'm talking the entire time. But this is just extemporaneously, right? This is how my brain is piecing all this together because I've been, thinking this out into different angles, and I want to get to the nitty gritty of some of my thoughts in terms of what's going on, right? So, this lawsuit comes in, and and the interesting thing is the lawsuits in New York have accomplished what they wanted to some extent, right? The lawsuit by these big companies, one of the things that happened was, the next version of the proposed regulations was released, by the regulators. And lo and behold, it had changes in terms of accelerating the timeline for them to be able to cross over adult use and a couple of other things that were friendly to them. And the person who sued based on the Dormant Commerce Clause, because he was an out-of-state person trying to get one of these CAURD licenses, there was a settlement agreement with the regulators in which the regulators essentially promised to hand him a license in the adult use round if he qualifies, but they settled just so they could remove the injunction holding up the handing out of these licenses and opening up of the dispensaries in, well, at that point, one region left, because they hand out the CAURD licenses according to regions tied to, population to ensure that there's sufficient supply. So the last lawsuit that came out, and the one that's in everyone's mind right now, is a couple veterans, right? And so in the initial, murder legalization bill, there are specific, classes of, people that these bills are trying to help, right? So we've talked about, people hurt by the war on drugs or whatever, and also you say like women-owned businesses and, service disabled veterans. So a group of veterans came along who, had plunked down, like I said, it's been 2 years since the bill was passed. They plunked down money for real estate, right? Thinking that things were going to get up soon. They've taken steps. They've made investment to be there on the front lines and have one of the first dispensaries open. And then the CAURD program opened up. And so they're suing along similar lines as, the coalition of the big companies, pointing out that issue of, the date, right? Not all retail dispensary applications open up the same date. And they pointed out some of these issues in terms of how, the regulators keep on, essentially expanding the CAURD program by awarding more licenses, by letting them, do all these different things to the detriment of all the people that are going to participate in the full adult use round, specifically the people that round, they want to hand 50% of the licenses to these, certain classes, including service disabled veterans. And, there's a limited amount of dispensaries that a state can support. And now there's going to be 463 cards handed out and operating, presumably, possibly before they get their chance. And so they came in and, they asked for a preliminary injunction and temporary restraining order. And what that is a party saying, we're being so irreparably harmed right now that this is untenable, right? And we need you, judge, to stop the other party, in this instance, OCM. We need you to freeze the CAURD program in its tracks. It's not just handing out more licenses. It's not approving anybody who has a license but wants to become operational, because all these folks are scrambling in one of the densest places that there are, with location restrictions, tied to houses of worship and schools, and certain localities that have opted in or not, to find property, right? And some of them are on the hook to pay this property. And so right now, the veterans, the plaintiffs, asked for everything to be frozen. And what the judge did here in this case was, and this is the same judge who, appears as handling both the coalition case, and the veteran case. And they do that at times, right? Because it's similar arguments, similar issues, it's efficient. And so what he did was he granted that temporary restraining order. He froze the entire CAURD program in its tracks, but it was a placeholder. Okay. It was just, it's certainly interesting that he did it, but this might just end up being a placeholder until, and I think that the current deadline for the state to respond is today. And the hearing is scheduled, and this TRO goes until the hearing on Friday. So that's not pushed, right? We may have an answer, right? On Friday, it's just a function of what will end up happening. What's that? Yeah. So on Friday, right? There are two things. There are two things that could happen, right? One thing is, he can deny the request for a temporary restraining order, in which case CAURD, unfreezes and keeps on going. And if he grants the TRO, it would extend through the point at which he makes a decision in the coalition case, on dueling summary judgment motions. In the coalition case, both sides are saying that they essentially have a winning hand. And so the judge, right, so the veteran plaintiff said, all right, we want to freeze CAURD until you, judge, this is what they actually asked for, until you, judge, make a call on the legality of the entire CAURD system in that other case with the coalition where they made similar arguments. And, the fear here, right, when we all saw this vulnerability from a ways out, and it was so obvious, is that, talking to other lawyers, we all geek out about this, that there is, an issue here that, it might not look good. It's possible that the CAURD program was improper from the beginning. But, what I want to put up on LinkedIn today and discuss is, look, judges know what's going on. Disrupting the CAURD program at this point would be an incredible destabilization in a market that's already really, really struggling. And so I'm not, an administrative lawyer. I always say that people need to think of lawyers like they think of doctors. You wouldn't ask a dermatologist to look at something up your, just like, right. But, having read some articles around, including a point made by an attorney named David Holland, are saying like, the only, line of reasoning that could help the state is saying that everything they did, the regulators, was due to an emergency. And so I frame this entire narrative to highlight two emergencies that were not of the regulators' own creating. The first is unlicensed stores selling, products that are unsafe. The second is the legislature created the conditional cultivation and processing, and there was 700 million weed coming out of the ground that needed someplace to be sold, right? And so everything they've done with the CAURD program has understandably really been for the purpose of safety of the populace and selling this surplus of weed so that these people aren't economically devastated upstate that they're intending to help. And the only other thing I'll say is, like, I want to dig deep into the chronology here, because you're making this argument that you're irreparably harmed. And part of the thing that occurs to me is, why couldn't the plaintiffs have brought this earlier? What just happened that changed this and made this completely untenable and justified asking for a preliminary injunction? And the only thing that was relatively recent was the increase from 300 to 463 licenses being handed out. And so I'm wondering if the judge can ding them on that. And then ultimately, maybe, right, even though it doesn't look great because they have strong arguments, maybe these emergency bases are enough that the program continues.
It's incredible insights, and it's very well summarized. Thank you very much for that. I'm sure everybody's going to get a wealth of information like I just did out of it. We've run over our time now, but hopefully we can get to touch base in maybe a week or two and see where all currently lies then and do a part 2 to this.
Yeah, I'm happy to do that. All right. So thank you so much for having me and letting me speak the entire time. Next time I'm going to interview you.
Not at all. My pleasure. Until next episode, everybody.